Hello, everyone. My name is Natalie Armstrong-Motin with Marketing Resolution, and it is my great pleasure to introduce viewers today to Teddy Snyder, a colleague in Southern California. Hi, Teddy. How are you?
Good morning. Hello, Natalie.
It's really nice to talk to you for several reasons. One of which is that you have traveled extensively in my neighborhood here in Normandy, France, and you and I can speak heavily accented French together, which is a really nice treat for me. I like that very much. But it's really a pleasure to talk to you because French is not the only other language that you speak. We were talking earlier about the various other languages that you are able to speak with your clients. And so if you don't mind, would you share with all the viewers what kind of practice you have and what those languages are?
Sure. I have a mediation practice. I am a full-time professional neutral. I do not represent any parties. I handle primarily injury cases. That includes workplace injuries in the workers' comp system, also longshore cases, Jones Act, and also injuries that are where the controversy is in the civil courts. That would be very commonly medical malpractice, collision, dog bites, slip and fall, those kinds of injury cases, which can range from soft tissue, fairly minor cases, to multi-million-dollar cases. You want to talk about languages?
Well, yeah, so the languages you speak, because you have such a rich background in the law, obviously you speak the language of a litigator.
The law, I think every lawyer recognizes, has its own language. And frankly, sometimes our clients don't know what we're talking about, but they're too intimidated to ask. But even for people who are dealing direct with insurance adjusters, they have their own language. And I've worked as in-house counsel in an insurance company, and I've worked with many, many insurance companies, and they are the shrine of corporate speak. And on one hand, we want to use plain language and all understand each other. On the other hand, being able to talk the talk shows that you're one of the in crowd. If you're an attorney who is working with insurance companies, you do want to be able to use the lingo. And I found also that every single area of the law has its own lingo. So you do have to be multilingual. So for example, in a California workers' comp case, we might be saying something like, well, the injured worker has received all the PD, but there's an issue about the DOI, and so we may have a TD overpayment, and of course he's claiming LP.
So your background and your expertise allows you to not just speak the language of all the people in the room, but also to act, I would assume, as a translator for the claimant or the respondent in a case, so that you can actually explain what the lawyers are talking about, what the insurance adjusters are talking about, so you can talk to people in kitchen English and help them work through these processes.
In the mediation I did most recently, I spent time with the claimant, explaining things that, frankly, I think her attorney should have explained long before. It's what we would call an old dog case. It had been around for a really long time before finally coming to mediation. And attorneys are busy, and sometimes they just assume that their clients understand what's happening. And I found, as a mediator, sometimes just being empathetic with an injured person is very important. And here's one of the reasons why mediation is so important, Natalie, is for an injured person, mediation may be the only time they get to come into a forum, meet with a neutral person, and tell their story. And that has a lot of advantages. If they don't get that opportunity, it can get in the way of being able to settle the case. It's cathartic for them. And this goes into the communication issue. Sometimes injured people tell me concerns that have slipped through the cracks. I had one case, and after a day of mediation, hours of mediation, we were settling the case. It was being written up. This was a workers' comp case, and the injured person said to me, "So when do I go back to work?" That was uppermost in this person's mind. That wasn't part of the settlement that had been worked out. That in the course of the negotiation, whether that person would be ever able to return to work, either had it had been taken for granted that this person would not be returning to work, but the attorney had never explained that. It hadn't been presented to me as an issue along the way. And here, sort of at the 11th hour, thank goodness I had built up enough trust and rapport with the injured person that he said to me, "When am I going to return to work?" And I put the brakes on things. Now that case did continue on to settlement, but we also put in the compromise and release some language making the status of that person's ability to return to work clear.
Right. And I know that one of the challenges for people is that if you're not an attorney, if you're not a mediator, this is a stressful environment. In the same way that when any of us go for any procedure or surgery in a hospital, or we find ourselves in an emergency room, that's not our comfort zone. That's not the language we speak. It looks funny and it smells funny and we don't know what to expect. And when we're under stress, we're not always thinking clearly about the questions that need to be asked. And that makes us not the best consumers all of the time. And so it really speaks highly of you and your practice that you understand all of the different people at the table, the advocates, the insurance folks, the employers, the employees, the neighbors, whatever the case might be, that you have this ability to be multilingual and multicultural so that you can really best help people. And I know that in the book that you wrote, and it's an old joke, but you really did write the book on these kinds of cases, and it's called What's My Case Worth? And I'm happy to put the link in the description bar and encourage people to log on to Amazon and buy the book. But having that kind of background really does set your practice apart.
Okay, so the full title, that's the subtitle. The full title is Personal Injury Case Evaluation. What's My Case Worth? What that book does is it sets out, I think it's 9, progressively more sophisticated approaches to how to evaluate a case. So it's initially, gut instinct is actually a bona fide way to evaluate a case if you have many, many years of experience. And that's why people use lawyers, for one thing, because for a plaintiff's lawyer, when you have a client, a prospective client, come in to talk to you, right away you need to size up whether there's really a case here worth pursuing. So you may not have a, to the penny kind of evaluation in your mind, but right away that attorney knows. On the other side of the controversy is most commonly an insurance adjuster, and an insurance adjuster has to set a reserve, a fund, which approximates an amount that will be able to satisfy this obligation. And adjusters have experience. Adjusters are trained, and the longer they're in the business, the more complex cases they handle, to have a gut feeling, and they know how to reserve a case. So unless you have that background, that foundation, gut instinct isn't going to work. Talking to the neighbors isn't going to work. Well, my next door neighbor said that his nephew was in a car accident and he got $1 million. And, and we've all kind of seen those television commercials. But that may not be appropriate for your case. In fact, I would say what the neighbor got is pretty much never appropriate. So, and then, at the other extreme, in cases with very high exposure, you may be looking at things like jury consultants who charge a lot of money. You may want to impanel mock juries. And there's many, many methods in between that apply to a personal injury case. In a workers' comp case, getting the printout, if you're the attorney on the case, whichever side you're on, reviewing the printout, doing the calculations is important. So what all of this is suggesting, and what you kind of alluded to before this last question, was preparation. I cannot emphasize enough how important preparation is. And I have been in mediations where people showed up on, again, both sides of a case, both the claimant and the employer or insurance company responding completely unprepared. They had not done the homework to know what their case was worth. I remember, this was not real recent, but the adjuster on a case kept telling me, well, we want to offer, it was a six-figure amount. We want to offer it this much. We want to offer it. And I kept saying, okay, well, what are you basing that on? Let's look at some numbers, some hard numbers here that we can extrapolate. And when I finally was able to get that person to retrieve the numbers, and we could sit down together in caucus means just one side meeting with the mediator, we were able to say, this case has a value about $2 million. So your six-figure offer, it was below 1 million, that's not going to cut it. That's why they're rejecting your offers. And I've seen many situations where people are coming to mediation without being fully prepared. This was another thing you and I had chatted about, Natalie, which was, when I send out a confirmation of mediation, I send out a very detailed instruction letter, and that may include very specific instructions about how to organize your brief. Okay, have a section about this, have a section about liability, have a section about damages. Is this an issue? Is that an issue? And yet people come and, sort of like how people treat the flight attendant's instructions on an airplane, those instructions have been completely ignored. So anytime you're going to sit down and negotiate, even without the help of a mediator, if you are not fully prepared, you're not going to get a good result.
And that's true, like you mentioned, that's true not just for people that are coming to us for our mediation or arbitration services, but that's true in all of life. Be prepared, absolutely be prepared. And you can help people overcome a lot of those preparation hurdles or hurdles actually in the room, because you can be evaluative, because you are a multilingual, multicultural mediator with such a rich background. And I think, again, that's one of the great things that sets your practice apart from so many others, is that very varied background and expertise. And I think that that's really important. Teddy, what is the best way for someone to reach out? What's the best way for someone to learn more about you or get a hold of you?
Well, I have a website. It's called wcmediator.com. There is a lot of information there. There are links, and there is a blog with more than 60 articles about mediation and about injury cases, and it's completely free to the public to access that information. There is a contact form. I believe there is a link at the top right of the landing page, and there may also be a form down at the bottom of the landing page that you can click on and send me a message through the internet. You can also connect with me on Twitter at wcmediator.com. You can find me on LinkedIn. Teddy Snyder is on LinkedIn. And there are ways to message me through those media as well.
Excellent. And of course, I will put all of those links in the description bar down below. I'll also include the link for your book so that people can get a really good idea about what their case is worth. Teddy Snyder from Southern California, it's been a great pleasure to speak to you. Merci bien, c'était fantastique.
De rien et merci à toi. Au revoir.
Au revoir. Listen, everybody, as always, if you or someone you know needs the mediation services of someone like Teddy, I encourage you to share this video, subscribe, and help people out. And as always, thank you for watching. Be good humans. Bye, Teddy.
Bye-bye.